Hello, hello, hello. Good evening, everyone. I hope everyone's doing great. How are you all doing today? All right. Well, thank you for joining me. Thank you all for joining me. I see that we have people coming in on Instagram, Facebook, YouTube, and TikTok, and I'm streaming on all these platforms. And so, hello to everyone. If you're new to my live, please say hello. Let me get to be introduced to you. And so, for those who do not know me, my name is Ifeoma Odunlami. I'm an immigration attorney from the Odunlami Law Firm. Hi, Irene. Hello, Dong. Hello, Pink. Hello, user 451 from TikTok. So, I have my law firm is in New Jersey, and however, we practice immigration law, which is federal law, and so we can represent people all over the world, really, and people all over the United States, definitely. If you have immigration needs, please feel free to call our office, 973-993-1900. We are very experienced with immigration cases, especially complex immigration cases. So we love the challenge. So if you or somebody you know is struggling with your an immigration matter, maybe you've been told by other people that there's no pathway, maybe you've been told that it's a maybe you've been denied, you've gotten denials, it could be helpful for you to reach out to us so that you can have a consultation or a case strategy. Let's look at your case. The past couple of weeks, I had a couple of consultations from people who have been here in the United States for maybe over 25, 30 years, who have been talking to various attorneys. And, sometimes they didn't ask the right question because we're able to find a pathway for them to get status. Of course, I'm not promising everyone that calls or contacts me that there is a pathway. Maybe not, but it doesn't hurt to do a consultation. I always tell people, don't even consult with one attorney, consult with several attorneys, because sometimes somebody might have some experience with a different type of case and might have been successful and may be able to use that success to your advantage. So I have a great topic today, and so I'm going to talk about this, and then when I'm done, I'm going to answer some questions. I have some good news, but I can't tell you guys yet. So when I can tell you, I will tell you, but I'm really excited about this, but I have to keep it to myself for a little while. And when I can tell you, I will share happily. So let us go into the topic. Hi, Celio from Zambia. Lovely to meet you, Celio. And hello, Sophia and Andrea. And we have a bunch of people joining in. Hello, everyone. So let's dive into this topic. So I've been getting this question: can the Trump administration revoke VAWA? Can it revoke T visa? Can it revoke U visa? And the answer to that is VAWA, U visa, T visas are they're actually law that is firmly entrenched in a statute. So the president cannot, by executive order, revoke or terminate these humanitarian protections, right? So I'm going to talk about VAWA because I want to go over some information about VAWA, but this really applies to all of them: VAWA, T visa, U visa. There is no way the president can terminate or revoke these pathways by an executive order. Only Congress can terminate these protections. And VAWA, for instance, Violence Against Women's Act, was enacted by Congress in 1994 with a goal of providing a special pathway to legal immigration for victims of domestic abuse or violence in the United States. And this is for people who otherwise would have to depend on their abuser to get them legal status. So, of course, it's clear that if you have somebody who's been abusive to you, then having them file documentation for you puts you in an extremely vulnerable state. So that's part of the guidelines of VAWA. VAWA is actually is part of a bigger program that protects people, victims of abuse. So it's not just even in immigration. Same thing with T visa. T visa is part of a larger program that protects victims of trafficking, sex trafficking, labor trafficking. All right. So now, although Trump cannot terminate VAWA, what he can do is to make it more difficult by imposing a more stringent review process. All right. So that's what I want to talk about today, because we are expecting that there will be a more stringent review process, and it already started. This actually started December 2024, before Trump came into power. They're now having interviews for VAWA cases, whereas before they never did. And that was because there was a lot of fraud going on with VAWA applications. So we do expect that there's going to be interviews, but it's not clear who's going to be interviewed. Everyone is not going to be interviewed. So I just want to let you know that. But there are people who are going to be called for an interview. Now, should that make you nervous? No. As long as you know what your case is not a fraudulent case, you really just need to make sure that you're properly represented, properly prepped, and go in there and tell your story. Now, they could also have more RFEs, requests for evidence. We expect that, and actually across the line in all case types, that is what we expect, that there's going to be more requests for evidence. And this is based on what happened during Trump 1.0. So now talking about VAWA, right, it's important that when you're putting your VAWA application that you submit a strong case. And the reason is because the Trump administration has indicated that when a case is denied, even a VAWA case, even a T visa case, even a U visa case, that person would be put in removal proceedings. In the past, the policy was basically to just deny the case and let it be, unless there was some indications of fraud or misrepresentation that the USCIS felt was serious enough. They would then refer it for removal. But this administration is basically saying with all case types, if there's a denial, they definitely will have a choice, and they will probably put that person in removal proceedings. So now this administration has just started, so we don't know if they're going to actually do what they say they're going to do. But so far, they're saying they're doing what they say they're going to do, especially when it comes to immigration. Not with regards to the economy, of course, but with regards to immigration, they are really pushing hard at making legal immigration more difficult, right? So let's talk about what we can do to make sure that your VAWA case is denial proof. So let's start with talking about what VAWA stands for. VAWA stands for Violence Against Women's Act. We all know that VAWA does not only apply to women, it applies to men, it applies to children, basically immediate relatives of US citizens or green card holders who have been subjected to abuse. Now, abuse can be, well, let me break that down. Let's just be clear who the actors are. If you're an immediate relative of a US citizen, which means you're the spouse of a US citizen, you are the parent of a US citizen who's 21 and over, or you're the child or stepchild or adopted child, meeting all the requirements of those terms. If you're the child of a US citizen or green card holder, then you can file for VAWA if you've been abused. But for this live, I'm going to really discuss the marital situation, because that's where we see a lot of filings and a lot of, scrutiny. So VAWA requires you to, first of all, prove that you're in a bona fide marriage. It requires you to prove that you've lived together with your spouse at some point. It requires you to prove that there's been abuse in your relationship. It requires you to prove that you're a person of good moral character, right? So I'm going to talk about those, take it one at a time. So bona fide marriage is where a lot of people get into trouble, right? Bona fide marriage means that your marriage has to be legitimate. So how do you prove that? First of all, you want to show that you have a valid marriage license, or if you got married through some kind of maybe you're not American and you have some kind of religious marriage or cultural marriage, you have to prove that that marriage is valid in the country, and typically America will respect that. However, one thing America does not acknowledge or approve as a legal marriage is polygamous marriage. So if you're married to more than, because I know in some countries, like in my country, Nigeria, a man can be married to more than one wife. If you're married to more than one wife, the second marriage is not a valid marriage, and United States does not, will not approve any polygamous marriage. Bigamous marriage is another thing, right? You're married to two people at the same time. That's bigamy in the United States. However, there's an exception carved out when the bigamous, the person who committed the bigamy is the United States citizen or the green card holder. But the VAWA self-petitioner cannot have a bigamous marriage. And that's where I move to the third thing, which is the divorce. If you've been married before, you must show that you were properly divorced. And that's where we get a lot of problems with a lot of cases from certain countries. So the divorce is not properly completed, and they get married to a US citizen or they get married to a green card holder. What that means is that second marriage or the subsequent marriage to the US citizen or green card holder is not a valid marriage. It's a void marriage, right? So I tell you guys this all the time. If you fall in love with a US citizen or green card holder and you've been married before, you must make sure that your prior marriage was terminated. And if you're in any doubt, get a divorce in the United States before you marry your spouse, because it's not an excuse that your spouse, your ex-spouse, was the one that filed the divorce and gave you the divorce decree and you didn't know it wasn't properly done. That's not an excuse that will fly. So it's really in your best interest to make sure that your divorce was properly done, not because you know people who told you. You want to authenticate that divorce properly the way USCIS would. And typically part of the way they do is to go to the courthouse and make sure that the court system can authenticate the divorce. If you're married in a traditional manner, then you want to follow the rules of that country with regards to terminating the marriage. In some countries, you would return the dowry, or you would, like some religious marriages, there are certain things that they have to comply with. But whatever it is, you want to make sure that it's properly done and that you can prove that it's been done. So now let me give you a little tip. This is something that a lot of people don't know. Common law marriages are valid in the United States. So a common law marriage is basically a marriage that says that that even though you're not legally married together, like legally married to each other, you don't have a marriage certificate, but for the purposes of for purposes of that state law, you have shown that you have resided together and held yourselves out to be a married couple. Now, there are some states that are common law states. Every state is not a common law state. I'm going to tell you the states: Colorado, Iowa, Kansas, Montana, Oklahoma, Rhode Island, Texas, Utah, New Hampshire, South Carolina, and the District of Columbia. So those states and the District of Columbia recognize common law marriages. So now, is it easy to prove there's a common law marriage? Well, you really want to work with an attorney on this, because the immigration officer is looking at things like, when did the relationship begin? What was your intent? And with respect to the relationship, were you generally known by spouses, by neighbors, friends, and the community? Did you introduce each other as your spouse? Do you have legal documents showing that the other person was a beneficiary, such as a life insurance? Do you have birth registration or school registration showing you and your spouse as parents, living as parents of a child, and that you guys live together? Do you have pension rights, that name each other as beneficiaries. So those are some of the questions that an immigration officer would be looking to ask to determine if you are indeed you can indeed be regarded as common law spouses, right? So if you're in a common law state, even though you're not married to your spouse, you may be able to file VAWA because you're in a common law state. So that's something that's really important to know. So going along, let's talk about we've talked about bona fide marriage, showing that it's a bona fide marriage, which means that you're legally authorized to marry this person. Your prior divorces have been properly terminated. You're not, it's not a bigamous marriage, it's not a polygamous marriage, and it's not a marriage that violates any kind of American law, such as getting married to somebody who's like child marriages. They won't be approving child marriages. All right. So let's talk about the requirement that you live together. So this is a requirement, another requirement that gets people, knocked out of the VAWA application, because you have to have lived together. You have to prove that you have lived together, right? You cannot file a VAWA petition without proving that at some point you live together. And what are the proof that you're going to show? You want to prove that maybe you have a lease together, or maybe if you're living with family or friends or whatever, maybe they can you can get affidavits from them, affidavits from the landlord, affidavits from your neighbors, proof that your legal documents are going to the same address. And sometimes USCIS will do a USPS check to see if actual mail is going to that same address. So you must show that you live together. Now, there's no requirement of how long you must have lived together. It's typically you must have lived together at some point. Nobody says it has to be this amount of time. So maybe one day, maybe a week. That's not a reason to deny your case if it's a short period of time. All right. Now, let's talk about abuse, right? Abuse. Abuse, I'm laughing because I'm seeing some people fighting on Instagram. So abuse can be either extreme cruelty or physical abuse, right? Now, there's a misconception out there that for you to be successful in VAWA, you have to show that you have a police report, you have to show that you have hospital records, you have to show that, some physical proof of the abuse. And I'm here to tell you that that's not true. That's a huge misconception. And most of our cases are really cases where it's extreme cruelty, not physical abuse. So physical abuse is really, it's easy for you to figure out. It's, somebody beating you, pushing you, hitting you, touching you unlawfully. Physical abuse, is easy for people to recognize. Now, the one that people have a harder time recognizing is extreme cruelty. And extreme cruelty, I tell my clients that extreme cruelty is when you think about behavior that the abuser exhibits to put you within their control, to control you, or to make you feel bad about yourself, or to diminish you. So it could be behavior such as somebody constantly monitoring you, accusing you of cheating, putting you in a position where you don't want to do certain things for fear of offending them, right? It could be a behavior that they exhibit that makes you feel like you have to walk around them, as if you're on eggshells. It could be behavior such as economic control. They refuse to let you go to work so that you can be totally dependent on them, or they make you go to work and they force you to hand over your money. Or it could be them. You have a joint account and they're running you in the red constantly, and threatening you if you don't allow them to do what they want to do. That's abusive behavior. It could be isolation. It could be threats of physical abuse, even if it's not physical abuse. It could be threats of physical abuse to people you love, maybe your pet, maybe your child, maybe threats to humiliate you in front of people, or actual humiliation of you in front of people, putting you out in the public and embarrassing you in public, maybe even writing things about you on social media, denigrating you. All that kind of behavior is abusive behavior. We consider them extreme cruelty, right? It could also be threats to get you deported, threats to call law enforcement on you, threats to file false claims to get your children taken away from you. It could be driving their car in an unsafe manner to make you afraid, right? Driving while drunk. They could be driving while drunk and endanger you. It could be dropping you off in an unsafe neighborhood, endangering you. So there's no requirement that extreme cruelty meet any pattern of conduct. Sometimes it could be a particular conduct. It could be a combination of certain conducts together that show a pattern of abuse. So I can tell you that I've seen a lot of conduct which I consider extreme cruelty, which maybe people may not, depending on where they're from. For instance, you might have a spouse shaving the wife's hair because he didn't like the hairstyle, which in their country would be, well, he's the head of the household. That's the way it's supposed to be. But in America, that's abusive conduct. That's a battery, actually. Or it could be somebody, I think there was a case I had where my client had been sexually abused by a police officer, and the spouse would always threaten to call the police on her because he knew that she had a special fear of police because of what she had gone through as a child, right? So if you're in a relationship that makes you feel bad about yourself, if you're in a relationship that makes you afraid, if you're in a relationship that makes you feel that somebody's exerting control over you, right, gaslighting you, you might qualify for VAWA. It's worth talking to an attorney, okay? Now, let's talk about where the abuse must occur, right? If you do not currently live in the United States, some of the abuse must have happened in the United States. That's a requirement. Some abuse must have happened in the United States. Or if the abuse happened abroad, you have to show that your abusive spouse, parent, or child was an employee of the United States government or a member of the U.S. military. Another thing is that the abuse must have occurred during the time you were married. So the abuse might have occurred before you got married, but you have to show that it continued during the marriage, right? Now, what else? Now, if you live in the United States, like it doesn't matter where the abuse occurred, it just has to have occurred during the marriage, okay? Now, let's talk about good moral character. That's another requirement. You have to be a person of good moral character. However, if there's something you've done which which will question whether you're a person of good moral character, that could be waivable, you know. And typically, we're looking to waive we're looking to file a waiver that can connect that conduct to the abuse that you suffered. So what do we do if, as part of proving your good moral character, if you're age 14 or older, you need to submit a police clearance for each place where you have lived for at least 6 months in the 3 years preceding the filing of your petition. Alternatively, you can get an FBI background check, which covers all states. So if you're younger than 14, USCIS will assume that you have good moral character, so you don't have to provide a police clearance. So now the evidence required according to USCIS is credible evidence. Now, does that mean you can bring any evidence you feel like? No. USCIS considers some evidence more credible than others. So sometimes you may not have evidence because of the nature of the abuse. So it's important to explain why you don't have certain evidence that would bolster your case. All right. So I think that's all I have for today. So let me look at some questions and I will answer them. All right, let me start from, let's go to YouTube. So Michelle says, can anyone come to the office to see you, or we have to talk to you by the phone? So Michelle, currently my firm is doing consultations via Zoom or via phone. We're not doing in-person consultations. If you need to book a consultation, you can call the office 973-993-1900. Ahmed Gaba says, I sent my EAD renewal through VAWA pending, and I got a receipt notice after 2 months. But my EAD category is CO9P. That's correct. CO9P is for the adjustment of status. So you must have filed, I hope you did file an adjustment of status with a VAWA, because that's where you would get the CO9P, and that would give you the work permit and the advanced parole in the same card. Okay. So let's see. Thank you, Kiden. I'm glad you find that informative. So let me ask a couple questions. I think somebody had a question about, good day, Ma. If you're not on that parole program and apply for asylum, did the pause affect you from getting a work permit as of now? No, the pause doesn't affect you getting a work permit, but getting the green card, there's a pause on that. That's my understanding. All right, let's ask a couple more questions. Let's see. All right, I'm looking at Instagram, and I'm just going through somebody that was just ready to fight everybody for some reason, and so I have to go through it to see if I can get a question that I can answer. All right, there's just a lot of angst on Instagram, so let me go to TikTok. I can't even find a question. Answer Korang says, can you travel with a VAWA advanced parole if you have pending VAWA application and adjustment of status? So answer, that's actually a really good question. If you have an advanced parole document, it allows you to travel. However, note this, CBP is not required to allow you to enter. They can conduct their own determination about whether you're admissible. So I would say that if you have an attorney, you want to talk to the attorney before you travel. And just to make sure that there are no issues, right? You want to make sure there are no issues with misrepresentation or fraud. Maybe back in the day when you applied for some visa to come to the United States, you want to make sure there are no issues that you think may not be issues, such as maybe you have some kind of arrest record, which you think was not a big deal because it was dismissed. That could be problematic. You really want to be careful about traveling in this administration for right now, because there's just a lot of stories going around about what's going on at the border. So I don't know. It's really your decision, but I would recommend that you talk to an attorney before you make this decision to leave the country. But then, having said that, a lot of people are leaving, a lot of people are coming back. So it's really what your risk tolerance is. So Shira says, my case was sent back to NVC after interview for K1. What can I do? Wow, Shiro. Well, that really tells me that there was a problem, because for them to send it back, it means they are likely trying to revoke the K1 visa. So we had a case like that, actually, and our client's K1 visa, he went for the interview, and for some reason, I don't even remember what happened, because they were not our clients by then, but the K1, the Department of State told them they were going to revoke the K1 and send the case back. And so when they came to us, they didn't know why the case had been denied. We did a FOIA and they just wouldn't respond to it. That's USCIS. They wouldn't respond to it. So we didn't know either. So what we told our client was, get married and let's file an I-130 petition for you. And they got married. We filed the I-130 consular process. And I'm happy to tell you that our client's former fiance, now spouse, is here in the United States, and we never quite understood why the K1 was revoked. But rather than fight them over that K1 or wait, for a long time to get the answer as to why it was being revoked, it was easier to tell our client, just get married and let's refile for you, and let us do this so that we can be in charge of making sure it's properly done. Okay. So Kaidan says, can I share my contact information for a consultation? Of course. Our number is 973-993-1900. 973-993-1900. I never know how to pin it on Instagram and TikTok, so forgive me, I'm not very techy. But you can also send an email to support, SUPPORT, @odunlamilaw.com. And guys, remember, there are people out there pretending to be me. If you go to TikTok, there are like 10 accounts with my face all trying to get money from people. That's not me. I want you to be very purposeful about using the information I give you about how to contact us. 973-993-1900. Support @odunlamilaw.com. All right, let me answer more questions. So Rashid Adeoshun says, I had an NTA for an overstayed visa. Where is it? But it was dismissed 2 years later. Congratulations, that's good. So you're no longer in removal. So can you travel with advanced parole under VAWA petition? Again, Rashid, the answer is the same thing I gave you. You want to be really careful because just because you have advanced parole is not a guarantee that CBP will let you through. And I don't recommend it, but I don't know your case. So it's best you talk to somebody who understands your case. And I'm telling people, just let's wait until we see what how this lawsuits, pan out. There's a lot of stuff that's going on with this administration that really doesn't comply with the law as we know it. And but this advanced parole thing has actually been something that predates the Trump administration. We've always advised people that advanced parole is not a guarantee that you'll be able to come back into the United States. All right. Yeah. Okay, let's see. So Fred Obo says, I applied for work authorization renewal for pending VAWA application since November 2024. Alongside the travel permit, I have received the receipt for the travel permit since December, but the receipt for the work permit is yet to be received. That's December, since November. That's a long time. You know what you should do? Just go ahead and reapply. Apply again for the I-765 because there are no fees. So you don't lose anything by putting in another application. In the meantime, you can reach out to USCIS and ask them what's going on, do an inquiry, but you lose nothing by applying again, just so that you're not just there, just waiting, okay? All right, let's see if, okay, so Pink Naomi says, I have a 25-year-old son. I'm a permanent green card holder. What do I do to get my son here? All right, Pink Naomi, that's a really great question. And it's an easy answer, but it's a long process. So if your son is single, then of course you can apply for him. If he's married as a green card holder, you cannot apply for him to come in here with an immigrant visa. So I'm going to assume that he's single. You can file the I-130. It's a consular processing. It's going to take time because I think I think F2A is almost current. It's F2B, which is what your son would be because your son is over 21. So I don't remember what the dates for the cases they're working on right now. But if you go to the visa bulletin, look under F2B. So type visa bulletin and whatever month we are in, maybe type May because May is already out. Look under F2B and it will tell you what case, the time for the case type for F2B applications, and that typically just gives you an idea of how long it's going to take. But F2B, all those cases on the preference, a lot of them are taking a long time. So yes, you can. What I'm going to advise you to just put in the application and let your child get on the line. Now, if your child has some special skills, maybe they can come here through national interest waiver, or maybe they can, if they have someone to employ them. There are different ways to come here, but if you have a green card, go ahead and apply for them and let them get online, okay? All right. All right. All right, let me keep going. Actually, give me a quick second. I need to make a note of something. All right, looking back. So Express says, if I'm married to an American citizen and I'm in a foreign country, when I'm coming into America, is it a case that my husband has to pick me up? Like, what if I want to surprise him? I don't know what this question is about, because are you talking about your spouse filing for you? I think your spouse would know if you are coming. I don't know. So I'm not going to answer that question because it's not an immigration question. All right, so let's see. All right, so let's go to TikTok and see if I can get a couple more questions. So somebody said, how long does it take before you accept appointment? Omar, first of all, we have to be able to assist you, because some people they have immigration issues that are not related to the kind of work we do. So if we determine that we can assist you, then our intake people will book you at the earliest convenience, at the earliest time for any of the attorneys. There are 3 attorneys here, so the quickest one, you'll get it. Now, it's easier to call and book, because when you self book on our website, sometimes it shows that we're not available for a longer period of time, but we can squeeze you in somewhere. So why don't you give a call and let's see how we can assist you. 973-993-1900. All right. So Gigi says, if I got a felony case dismissed, not conviction, can I still proceed to the consular appointment? Gigi, it depends on what this case is about. I can't answer abstract questions when it comes to criminal cases, okay? All right. So with Trinity says, I secured a marriage license with my ex. We never did get married. What's your advice? If you never did get married, then you can't get a marriage-based petition unless you live in a state that recognizes common law marriage, and you're eligible for to be considered common law spouses. Okay. So Gospel says, can you travel with a green card? Yes, you can travel with a green card. All right. All right, I think, let's see. So Rowan said, I came on a K1, my spouse abused me and we separated. Only proof of residency I have is online receipts. So Rowan, if you came on a K1 but you did marry your spouse, you might file VAWA. So how about you reach out to our firm? Let's see whether you may be eligible to file VAWA, because sometimes victims of abuse don't have the required evidence, but if you can explain why, and your case, you have a credible, your declaration is credible, you can still file and get a VAWA approved. It really depends, with VAWA cases and T visa cases and U visa cases, it's really, how well you explain what you went through a lot of the times, okay? So Mitchell Leas Salmon says, can someone who's already married in the United States file a fiancé visa for someone else in another country? And the answer is no, you're married. You cannot file a fiancé visa, because for you to file a fiancé visa, you have to be eligible you have to show that you're single and you're eligible to file a fiancé visa. A married person cannot file a fiancé visa. All right. So Mike Ayer says, I have a question. I'm out of status. I'm an international student married to a U.S. citizen. How long do I have to file the Form I-485 after my spouse files the Form I-130? Why are you waiting? Go ahead and file the I-485 right away. You could have filed it in one step. Okay, Mike, congratulations on your marriage. All right. So CC Yankee says, so what's new on green card holders and travel? Same thing that I discussed. Green card holders can travel. You just want to make sure that when you come back, you don't get coerced into signing the I-407, which means that you've abandoned your green card and you won't be allowed to come in. You want to make sure before you travel, you don't have anything that makes you inadmissible, because otherwise, if you are inadmissible, even though you'll be allowed to come back in, you may be sent to immigration courts with the service of a notice to appear in immigration court, and there you have to fight to keep your green card, okay? So Irene says, can you remove your conditions on your green card if you're separated from your partner? Of course. That's what that is supposed to, the removal, removing your conditions with the I-751 allows you to do so through waivers if you're no longer with your partner. Either the waiver of abuse, waiver of divorce, waiver of extreme hardship, or waiver of death if that person has passed away. So Irene, yes, you definitely can remove your conditions, and you don't have to wait for your green card to expire or for it to be near expiration. If you suffered abuse, you can file right away. If you're using the waiver of divorce, you can file once your divorce is through. And if the spouse passed away, you can file right then. So you definitely can do that, okay? If you need assistance, because we do a lot of cases like yours, our number is 973-993-1900, or you can email us at support@odunlamilaw.com. All right. Okay, I think it's looking for more questions. All right, I'm looking for another question. So My Kitchen Mocktail says, can I apply for the US visa now because I've been to the state twice and I was denied in the year 2020 and tried again, but I was told to reschedule for another day. Honestly, My Kitchen, nobody can really give you a definitive answer on that, because applying for a visa, and I'm assuming it's a B1, B2 visa, is really discretionary. If the if the consular officer feels that you don't have enough ties to your country, or they feel that you might be a flight risk, that you'll come to the United States and not go back, they may not give it to you. So I'm going to advise you, if you want to go for B1, B2, the thing to do is to bring documents that show that you are not a risk of, not returning to your country. And does that mean they're going to look at those documents? Nope, but at least have it in case they're inclined to look at it. All right. So TPS has been canceled for Cameroonians. Does it mean that they will be put on deportation proceedings? I have heard that they plan to cancel TPS for Cameroonians. Whether they'll put them in deportation proceedings, they will try to deport them, that's for sure. But we don't really know what they're planning to do. And I think there's a lawsuit, or if there's not one now, there will be lawsuits in the future on that, okay? All right. So Ahmed Gaba says, the receipt notice class. Okay, let me go back. He says, I sent an EAD renewal through VAWA pending. I got a receipt, but my EAD card category C09P and the receipt notice class category C31. Does that mean I'm eligible for automatic extension for 50 days? No. So the C09P is the adjustment of status, is the I-485. If you file an I-485 and you apply for a work permit, you're using the code C09P. Now the C31 is for the VAWA, and you don't get a work permit with C31 until the VAWA is approved. So if you applied for your adjustment of status and put the code C31, you're not going to get a work permit until the VAWA is approved. So you might want to apply again for the work permit using a C09, because that's what is going to get your work permit sooner. And with a CO9, yes, there's a, people can extend before, if they file for renewal before the expiration. So I hope that answered your question. All right, let's see. So Shanna Lawrence says, I have a biometric appointment. What happens after if I have a criminal record? So Shanna, there's been stories about immigration, ICE, going to places where intending immigrants or have appointments and taking, detaining them. I haven't heard of that for a biometric appointment, but honestly, I think it might be a good idea to talk to a lawyer so that you can really get some information about what to do, because I don't know enough about your case. I don't know anything, and I will not give you advice on something that I don't know anything about. Famara says, I have submitted an I-864. I don't meet requirements, but can I use my assets? You could, but remember the assets you're supposed to use. There's a calculation for those assets. You want to make sure that you meet them. And I have to tell you, USCIS, sometimes the officers don't understand this calculation. So if you have a joint sponsor, that might be an easier way to do it, okay? So let's see. So Queen Victorian says, is it mandatory that you receive a work permit before your green card? Well, typically you're supposed to receive a work permit before your green card, but sometimes the work permit takes so long that there are people who have actually received their green card before the work permit. So, I don't worry if you get a green card, what do you care that you didn't get a work permit? Now, if you need your work permit because you need to work, then you want to do something about it. Either you call USCIS, put in an e-inquiry, put in another work permit application if you didn't have to pay for it, or just follow up with them, okay? All right. So Shanna Lawrence, if you have a question and you're a client, then give us a call. Let's answer your question. We won't answer the question here on social media, okay? All right, we want to keep your information confidential. All right, let's see, who else has a question? I think that's all the questions I've seen on YouTube and Facebook. So I think I'm gonna head out because I think that's all, but hope you guys are doing well, and I hope this was helpful to you. If you know somebody that would benefit from this live, please feel free to forward to them, and I will see you guys next week. Take care.